All right, good morning, everyone. We are having another webinar today, and we're going to get started here. Today's webinar is called Native Americans with Disabilities Empowered Through Self-Advocacy, Supports and Accommodations for Students with Disabilities in Post-Secondary Education. And now that I'm seeing that, I think that might have been our last title. Today we're going to be talking about education, but we're also going to be talking about transition services as well. I'm going to go ahead and get us started. My name is Austin Moore. I'm a member of the Samish Indian Nation with ties to the Little Shell Chippewa tribe on my mother's side. I'm an attorney at the Law Center, and with me today is my colleague Kayla Jankowski, and I'll turn it over to her to introduce herself.
Good morning, everyone. My name is Kayla, and I've been an attorney with the Law Center for about 10 months, and I work on the Children's Welfare and Education team, and I'm from Colorado. Nice to see you all.
Okay, so first I'm going to go over a few of the webinar guidelines. So it would help us out with our funders and us keeping track of data in order to make sure that these webinars are helpful and getting out to the right audience. If you could provide your name or agency and tribal affiliation in the chat box, and then whether you are an individual with a disability or if you're a parent, advocate, self-advocate, professional, or other. The way we're going to do this webinar today is feel free to leave your questions in the chat, but we're going to have a period at the end of the webinar in order to make sure everybody's questions are addressed. And then if you have any questions, then we can answer them at that point as well. Just so you all know, this webinar is being recorded and will be posted to our YouTube channel as well as our website. And then at the end, we will post a few questions about the webinar in order to get feedback to improve our outreach and services. Just a few things about the Zoom webinar format. You should be able to enter into the chat box messages. If you look at the bottom, there should be a to button. You can select whether you want to message an individual person, or if you want it just to go to host and panelists, which will be Kayla and I, or if you want to send a message to everybody, it gives you that option. You can also make use of the Q&A function if you want to just ask questions of us, so then we can monitor them and see them and address them at the end. But just wanted to point that the chat and the Q&A should be enabled. So I'm going to introduce our Law Center really quickly. The Native American Disability Law Center serves Native Americans with disabilities living in the Four Corners region. We provide advocacy, referral information, and educational resources. We also monitor facilities on the Navajo Nation, group homes, detention centers, etc., to ensure persons with disabilities are provided with the services they need in the least restrictive environment. We also provide legal advocacy and representation in disability-related discrimination, including housing, employment, education, voting, and others areas. And then we also provide advocacy and legal representation to Native American students with disabilities in education-related issues. So today we're going to be talking about the IDEA Act, which Kayla will talk about. First, we're going to be talking about the Navajo Civil Rights Act, which I will be talking about. And then Kayla will also be talking about transition planning and services. And then we'll have a Q&A session at the end. So I'll begin with a little bit of background on the Navajo Civil Rights Act. Okay, so the Navajo Nation has a long history of advancing and promoting the rights of Navajos with disabilities, including its recent passage of the Civil Rights of Individuals with Disabilities Act. This was passed in 2018 and can be found in different sections of the Navajo Nation Code, including Chapter 15, Section 604B, Chapter 10, Section 1402, Chapter 13, Sections 4501 through 4510, and 4801 through 4809. So the Navajo Nation Council found that the most effective means of ensuring that individuals with disabilities are provided equal access to employment, housing, education, services, and building, whether they're governmental or private, is to incorporate those rights into the Navajo Nation Code and replace the existing code with more substantive civil rights in order to make the law both specific and enforceable. And this is the Civil Rights Act. So the Civil Rights Act states that in harmony with traditional and common law, it is the policy of the Navajo Nation to respect, revere, and protect all individuals, their communities, and their unique qualities. So specifically, as the Navajo Nation Civil Rights Act applies to education, this can be found in Chapter 15 of the Navajo Nation Code in Section 4505. And it states that no student with a disability attending any school located on the Navajo Nation shall be denied a free, appropriate public education designed to meet his or her unique needs in the least restrictive environment. So in the context of education, for example, this law would allow students with disabilities to request reasonable accommodations from their schools, such as having a ramp built to allow a wheelchair user access to a building, or to allow a student more time to take a test. Things like that. Now I'm going to go into a little bit more detail about the definitions that would apply to education that are found in the Act. So between Navajo and federal laws, there are a lot of terms that share similar definitions. So as I said, the Act contains 4 main definitions that relate to one another. The first being disability. So in the Act, disability is defined as a mental or physical or mental impairment that substantially limits an individual's ability to engage in one or more life activities. So the question might be, what is a major life activity? So these activities would include caring for oneself, performing manual tasks, things like seeing, hearing, eating, sleeping. Other life activities include operation of major bodily functions, such as functions of the immune system, cell growth, digestive, bowel, bladder, things like that. So they're both related to physical and mental disabilities, as well as physical and mental life activities. Another definition is reasonable accommodations. So these are defined as necessary and appropriate modifications, not imposing a disproportionate or undue hardship needed to ensure a person with a disability is able to obtain, access, or participate in a particular right, benefit, or opportunity. So there's actually 2 definitions here. The first being reasonable accommodation, which is those modifications, and then undue hardship. And then undue hardship is defined as an action requiring significant difficulty or expense when considering the following factors. So the nature and cost of the accommodation, the overall financial resources of the specific facility, the overall financial resources of the covered entity, as well as the type of operation of the covered entity. So in other words, you can sort of think of this as a balancing test between the cost of the accommodation and the ability of the program to provide the accommodation. And then just real quickly, just how these definitions interact with each other, as well as some burdens of proof and some of the remedies. So to begin, the Navajo Civil Rights requires that medical evidence is necessary to establish that an individual has a disability. So sources of medical evidence may include documentation from medical facilities, doctor statements, letters, but they can also come from traditional sources, as the Civil Rights Act allows. So an individual seeking the protection of the Civil Rights Act will have to demonstrate whether he or she has a disability, as we defined earlier. So once that has been established, that an individual has a disability, then the ball swings towards the other way. The denial of a request for reasonable accommodations can only be made by demonstrating undue hardship. So let's say, for example, a student provides the school with a doctor's letter stating that he or she has a visual disability and requires that communication be provided in an accessible format, thus establishing a disability under the Act. The school then need to consider the resources available to provide this accommodation. So generally providing documents in Braille, large print, other alternative formats are not undue hardships. But in an extreme example, say the individual requires or requests a helicopter to fly them to school because they need a ride, that's where it's going to be an undue hardship. So that's unrealistic, but it kind of shows the balancing act and sort of case-by-case analysis that goes into these determinations. As for remedies, what's special about the Civil Rights Act is that individuals can actually seek remedies for violations of the act in the form of legal and equitable relief in the courts of the Navajo Nation. So the Civil Rights Act might be short compared to a lot of the other laws, but it does contain a lot of important protections for individuals with disabilities on the Navajo Nation. So I just wanted to cover that a little bit since our service area focuses a lot on Navajo Nation. We had a webinar a few weeks ago with one of our attorneys, Alexis Dela Cruz. She delved into a lot more of this in detail. So I can provide that link in the chat if you'd want to check that out and get more detail. Mine was a pretty broad overview. But now I'm gonna stop sharing and switch it over to Kayla's presentation. So give me just a moment. Okay, are we able to see the PowerPoint?
Yeah, it looks good. Thanks, Austin.
Okay.
Okay, so I'm going to give a brief introduction to the IDEA, and then we will talk in depth about transition planning and services under that law. So the IDEA stands for the Individuals with Disabilities Education Act, and it's a federal special education law that guarantees certain protections and rights to students with disabilities and their parents. IDEA is a federal law that sets minimum requirements that states have to follow. However, a state can pass special education laws which adds additional protections. So for example, a state could require that IDEA applied to students past the age of 21 when the federal law itself only requires that it apply to students until they're 21. So wherever folks are, they should familiarize themselves with the law in their state. There's two parts to IDEA. Part C applies to children under 3, and Part B applies to children over the age of 3. The IDEA no longer applies to a student once they either graduate from high school with a regular diploma or they turn 21. Or like I mentioned, if the state passed a law to extend that time, they could have the protection of IDEA until they are older than 21. For the law to apply to a student, they must be evaluated and found eligible by the school district through a process that involves something called an eligibility determination team meeting. So what IDEA does is it guarantees free public education, which a lot of people call FAPE, to students with disabilities in the least restrictive environment, LRE. You heard Austin mention those terms in relation to the Navajo Civil Rights Act. And now I'll give you some more detail on what those terms mean. So a free or appropriate public education means special education and related services that are provided at public expense, under public supervision and direction, and without charge. So the family or the student should not have to pay for any of these services. It should meet the standards of the SEA, including the requirements of this part. And SEA stands for State Educational Agencies. So in New Mexico, the SEA is the New Mexico Public Education Department. In Arizona, it's the Arizona Department of Education. In Utah, it's the Utah State Board of Education. And in Colorado, it's the Colorado Department of Education. The school district must include an appropriate preschool, elementary school, or secondary school education in the state involved. And it all must be provided in conformity with an individualized education program that meets the requirements of the rest of the law. So the definition of least restricted environment is that to the maximum extent appropriate, children with disabilities, including children in public or private institutions or other care facilities, are educated with children who are non-disabled, and special classes, separate schooling, or other removal of children with disabilities from the regular educational environment occurs only if the nature or severity of the disability is such that education in regular classes with the use of supplementary aids and services cannot be achieved satisfactorily. So this basically was added to prevent schools from taking all students with disabilities and putting them in a separate area to make teaching easier. It's best for students to be included with their regular education peers as much as possible, unless absolutely necessary. So IDEA also provides protections for students with disabilities and their parents. There's a long list of protections, but for example, some of these protections include requiring schools to provide specialized instruction to the student, requiring schools to follow certain procedures before disciplining students with disabilities, along with other procedural safeguards during the evaluation and IEP processes, and establishing parental rights to participate in educational decisions. Additionally, the IDEA requires schools to provide transition services to students by the age of 16 and as early as 14 if that's needed for the student. So to give some definitions of some of those terms, specialized instruction means that the instruction given to the child is unique to their needs. There's not a cookie cutter approach to the accommodations or services that each student should be getting. And procedural safeguards are procedures the school has to follow before doing something to change the student's education. So the purpose of the IDEA, as written in the law, is to ensure that all children with disabilities have available to them a FAPE that emphasizes special education and related services designed to meet their unique needs and prepare them for further education, employment, and independent living. So as we transition to start talking about transition planning and transition services, you can see that in the very purpose of the law, they included that students should be prepared for their lives after high school. So that was a very brief overview to the IDEA in general, and there's a lot of specifics that go into getting your child evaluated, finding them eligible, creating an IEP, which again stands for an individualized education program. And it's basically a document that lays out the special education instruction, supports, and services the school will provide to the student to meet their needs. So that all is a ton of information, and we have a handy parents guide on IDEA on the Law Center website, provided at the link below. Maybe Austin, you can put that in the chat as well. And that way, if you need more background information, you can look at that resource. So for the rest of the presentation, we'll be talking specifically about transition planning and services under the IDEA. So transition services are things that are provided to students who are found eligible under the IDEA. And they are services and activities that help students successfully transition from high school to life after high school. These services should be aimed to help a student succeed in post-secondary education, vocational education, employment, community participation, and/or independent living. It really just depends on what the student's goals are and what their needs are. Services should also be provided in a manner that is sensitive to a student's cultural background and native language. So examples of transition services that can be provided include instruction, related services, community experiences, the development of employment and other post-school adult living objectives, acquisition of daily living skills, provision of a functional vocational evaluation, special education, if provided a specially designed instruction or a related service, if required to assist a child with a disability to benefit from special education. Again, not every student will require all of these, but that's a list of things that are available, and there are more besides the ones on the list. So a very important part about transition planning is that the plans and services need to be individualized for each student. So each student has different needs, and therefore their transition plan and the services they get should reflect those needs. They should also reflect the student's strengths, preferences, and interests. So it's critical that students and parents provide input on post-secondary goals and the services that they think the student will need after high school. So transition planning will start as early as the age of 14 if that is determined to be what the student needs. Otherwise, it will start at age 16. And when transition planning starts, the student must be invited to participate in the IEP meeting where the transition planning and services will be discussed. So as I mentioned, the type of things addressed in the transition plan will be individualized, and they can address any part of the student's life after high school where the student may need support. So that could include things like self-advocacy skills, employment, education and training, independent living, and community involvement, or anything else that the student or parent can think of that the student might need help with. So to give a more specific description of how the process actually starts, how it can start is, as I mentioned, as early as age 14, if the student and parent think that the student should get started with transition planning earlier than age 16, the student or the parents can ask at an IEP meeting to discuss transition planning, or they can request an IEP meeting specifically to discuss transition planning. At the IEP meeting, the parent or student should ask the school to complete age-appropriate transition assessments. These assessments will include things like student and parent interviews, interest and skill inventories, and other tools. Assessments that are identified as appropriate for the student should be listed in the student's IEP. So if the school agrees to do certain assessments, make sure that they write that down in the IEP. The student and the parent should participate in the assessment process and let the school know if they do not think the results of the assessment are accurate. So if the student keeps saying that they want to be a welder, but the assessment results say that the student wants to be a chef, you should definitely speak up so their transition services are accurate with what their goals are. And the assessment results and feedback from the family will guide the accommodation services and goals added to the IEP to help the student meet those goals. So as I was mentioning about the importance of an individualized plan, the family and the IEP team should be sure to discuss things like the student's goals, dreams, and aspirations, the student's needs, abilities, skills, and the amount of assistance that they currently need. What are the student's desired outcomes, and what outcomes do the parents desire for them? What accommodations and services does the young person need now to help them prepare for life after school, and what assistance will the student need after school? Next slide, please. So after the assessments are completed, the IEP team should meet to discuss the assessments and come up with the appropriate goals and services to add to the IEP to address those needs. So the IEP, once it's completed, should contain appropriate, measurable post-secondary goals based on age-appropriate transition assessments related to training, education, employment, and where appropriate, independent living skills, and the transition services needed to assist the student with a disability in reaching those goals. So other entities that may be involved in the transition planning process, or other entities may be involved in the transition planning process. So an example of one of these types of entities could be a vocational rehabilitation agency or a VR agency. And there's one in each state and territory, and on the Navajo Nation, the Office of Special Education and Rehabilitation Services, which is a federal office, provides VR services to eligible American Indians with disabilities. So in order to get VR services, in most cases, a student will have to be found eligible, and they must apply and meet the following criteria to be found eligible. So they have to have a physical or mental impairment that constitutes or results in a substantial impediment to employment and requires VR services to prepare for, secure, retain, advance in, or regain employment. Students who have gone through the evaluation and eligibility process of the IDEA and have been found eligible are likely to meet those requirements. So that shouldn't be a huge hurdle to jump over. So VR agencies help people with disabilities make informed choices about their careers by providing a continuum of services to achieve employment outcomes in competitive integrated employment or supported employment. VR agencies will provide students with disabilities with services based on their individualized needs, and the VR agency can send a representative to participate in IEP meetings. The participation of a VR agency representative on an IEP team helps to ensure that there's a smooth transition from the transition services provided in the IEP to the services that will be provided by the VR agency to the student after they graduate from high school. VR agencies can also provide pre-employment transition services to students with disabilities, and I'll explain more about what those are. Next slide, please. So pre-employment transition services are offered as an early start at job exploration and are designed to help students with disabilities that are eligible or potentially eligible for VR services to identify their career interests. They include things like job exploration counseling, work-based learning experiences, which may include in-school or after-school opportunities or experience outside the traditional school setting, including things like internships that is provided in an integrated environment in the community to the maximum extent possible. Counseling on opportunities for enrollment in comprehensive transition or post-secondary educational programs at institutions of higher education, workplace readiness training to develop social skills and independent living skills, and instruction in self-advocacy, including instruction in in-person centered planning, which may include peer mentoring, including peer mentoring from individuals with disabilities working in competitive integrated employment. So you can really think of VR agencies and the pre-employment transition services that they provide as, experts and expert services that can be used to assist the school in providing the student with a disability with the services that they need. So important requirements that you should keep in mind that the school has to follow when coordinating with other agencies include that the school must invite a representative from the public agency responsible for paying for the services or providing services to the IEP meeting. So that would be like a representative from the VR agency, and the school must get consent from the parent to invite the representative to the IEP meeting. So if the parent says no, the representative will not be invited. And ultimately, the school is responsible for implementing the IEP. So say the school puts in the IEP that the student will receive career counseling from the VR agency. If the VR agency somehow drops the ball and doesn't provide the services that they agreed to, it is ultimately the school's responsibility to find another provider for that service. So next, I'm going to be talking about graduation pathways, which is another important thing to keep in mind as part of the student's IEP, and is related to the transition planning process. So there are different graduation pathways that are available for students, and one will be selected by the IEP team and will be noted in the IEP. And it's important for students and parents to be aware of the differences between the different graduation pathways. So the specific names and rules related to each graduation pathway that I will be explaining over the next couple of slides are specific to New Mexico, which is where I do most of my practice. And other states may call their different graduation options by different names and have slightly different requirements for each option. But the important takeaway from what I'm about to explain is that there are different graduation options available to students with disabilities, and there are meaningful differences between a standard high school diploma and other graduation options. So if someone on your student's IEP team suggests selecting a separate graduation option from the standard high school diploma, be sure to ask the IEP team to explain the different options to you and what that means. So the first option is a regular high school diploma, and the standard high school diploma is awarded to most students in the state that is fully aligned with state standards, or a higher diploma, like if they were taking harder classes or take college classes. A regular high school diploma shall not be aligned to the alternate academic achievement standards. So meaning to get the diploma, you have to follow the state's graduation requirements, and it will not include a recognized equivalent of a diploma, such as a general equivalency diploma, a certificate of completion, a certificate of attendance, or a similar lesser credential. So another option is the modified graduation option, which is meant to develop the student's career interests. Students on the modified option will take the general assessments that the other students take and will be permitted to have accommodations while taking them if needed. The IEP can also be used to establish individualized passing scores for state assessments. This graduation option accounts for the individual student's strengths, interests, career preferences, and needs. It allows for the substitution of classes as appropriate. So this graduation option is more flexible. It allows the IEP team to be flexible with, what requirements the student needs to meet to graduate, what their class schedule looks like. They don't have to follow the general state rules for which classes every student has to take. And it does allow for a decent amount of flexibility. So the ability graduation option is another option, and it's an individualized alternative program of study based upon meeting or surpassing IEP goals and objectives. It's designed to meet the student's needs with IEP goals, objectives, and benchmarks. And it is typically chosen for students with severe cognitive and or physical disabilities or students with severe mental health challenges. This can include modified graduation and assessment requirements. So this option is for students who need even more flexibility than under the modified option, and allows the IEP team to really work with the student to choose graduation requirements that fit with their goals and their needs and abilities. So while when the IEP team is selecting a graduation option, they need to consider the standard graduation option first. You shouldn't be receiving your student's first IEP and it just say that they're going to be on the modified option. It should be something that's discussed with the whole IEP team, including the student and the parent. If the IEP team changes the student's program of study from the standard to the modified option or to the ability option, the team must justify and document the reasons for rejecting the standard program of study on the IEP provide parents and students with the definition of the standard program of study and explain the differences between it and the program selected. So the potential consequences of a modified or ability graduation option are very important for the family and the student to consider, because it sounds really great to have a graduation option that allows you to substitute classes, be flexible with your graduation requirements, but that does come with some downsides. That's why it's so important that the school really explain to the student and the family about the pros and cons of choosing one of these different options. So most four-year colleges do not accept anything but the standard high school diploma. Community colleges may and do accept them, but may also require a placement exam before the student is admitted. It's important to note that a student who graduated with a modified or ability diploma could enroll in a community college for 2 years, get their credits, and try to transfer into a four-year college if that is what they wanted to do. And it's also important to note that not all branches of the military accept these diplomas. So again, it's really important to think it through and not just let the IEP team decide for the family. So another thing to keep in mind, if a student is put on a separate graduation pathway, is that FAPE must be provided until the student graduates with the standard high school diploma or turns 21. So if a student is put on one of a modified or ability pathway, the state and school district must continue to make a free appropriate public education available to any student who graduates from high school with a credential other than a regular high school diploma. And while FAPE under the IDEA does not include education beyond grade 12, states and school districts are required to continue to offer to develop and implement an IEP for an eligible student with a disability who graduates from high school with a credential other than a regular high school diploma until the student has exceeded the age of eligibility for FAPE under state law. And then it's also important to note that once the student turns 18, unless there's an alternative arrangement like a guardianship, the student will have the ability to make their own educational decisions at that point. So they could graduate with a non-standard high school diploma and be under the age of 21, but decline to engage in any services that the school is still willing to provide them. So lastly, I want to describe some general IEP meeting tips, and this will apply when you're talking about transition services or any other part of having an IEP. It's a very interesting and novel kind of situation to be in, and it always helps to bring a notebook and ask to bring someone to support you, so maybe they can focus on taking notes and you as the student or parent can just focus on what's being said and making sure you understand everything. It's also important to be polite but firm with the school staff when voicing any requests or concerns you have with the IEP. Ultimately, the IEP is for the student and it's not for the school. So don't feel bad about asking for what you need. Don't feel bad about asking school staff to explain acronyms or abbreviations on the IEP or any other terms or concepts that you might be unfamiliar with, because there are a lot of things that are just not intuitive and have special meanings that are involved in special education law, and you absolutely have the right to understand what they mean. If you make a request for something like a service or a goal or any other change in the IEP, you can, and the school says no, you should ask the school representative to provide you with more information as to why the request is being denied. And you should also ensure that all of your proposals are well documented in something called the prior written notice. So All changes to the IEP have to be documented in the prior written notice, which is a document that is at the end of each IEP, and it goes through what was discussed at the meeting and what the IEP team decided. So even if you propose a service that you want for your student, if the school says no, they need to make sure that they write it down in the prior written notice that you requested it and what their reasons for denying it are. Having your request written in the prior written notice can help a lot if you decide to seek legal advice or representation down the road. So another piece of advice is to make informed choices, ask questions, and don't feel rushed. Take the time you need to fully understand and participate in the discussion about what goes into the IEP. If you do not get to address all of your requests or concerns during the meeting, it is totally appropriate to ask for another meeting. And if generally IEPs are reviewed once a year, but you have the right to ask for an IEP meeting at any time. So if you notice something 2 months after an IEP meeting that is in the IEP that you think should be changed, or if you have an idea for a service that the student might benefit from, you can go ahead and ask for an IEP meeting at any time. And then lastly, make sure to document your communication with school staff in writing. Again, this helps if you decide to seek legal representation, and it also just helps in having conversations with the school and holding them accountable to the things that they said they would do. And now Austin is going to play a quick video. I think it might take a second to set up, so bear with us.
Okay. Hear it okay?
Yeah.
It is important to start talking with children early about what transition after high school is going to look like. But the transition plan itself must be in place at the age of 16 in the IEP. They should include post-secondary goals as well as transition services. So those post-secondary goals should be very specific, not vague aspirational goals, but very concrete steps that you expect your child to take after high school. It is so important that they have particular steps that they're going to take. What types of services? Do they need to visit college campuses? Do they need to be familiar with how to navigate in the community, how to self-advocate, how to ask for the services that they need? The transition plan should include realistic but achievable goals. For example, some students might say, I want to play in the NBA after I graduate from high school, and they're not playing basketball in high school. That would be an aspirational goal, but one that's not very realistic. But a realistic goal would be to attend community college to get a technical degree, or to go work in supported employment in a veterinary clinic if that student is really interested in animals. If it's not realistic to expect that a student is going to be in the tiny percentage of those who get to play in the NBA, but the student really loves basketball, then they might be able to work as maybe volunteer initially as a manager on a college sports team or a local sports team, or go to community college and get a degree in something related to athletics, like athletic training or something like that. So there are a lot of ways that they could work either as a volunteer or eventually in paid employment in a field in which they're particularly interested. Parents know their children better than anyone. So you know the conversations that you've had, you know what your child is interested in, and you can share that with the IEP team. You can talk about the things that you know your child wants to do. And of course, the child should be a part of the process as well. They should be attending the IEP meeting and adding their thoughts and opinions and feelings about what they want to be doing after high school. But the parents really are an important participant in that process because, again, they know the child better than anyone and have shared in helping create the dreams and the vision that the child has for the future.
Thanks, Austin. So now we can open it up to questions and answers, unless, Austin, you have anything to add before we do that. So the question is, I see the parents guide, but is there a transition guide / workbook for the student with disability, or workbook with worksheets, resources, tools, and information to help them transition to adulthood? So as far as I'm aware, the Law Center hasn't created one like this. Austin, let me know if you can, or if you know differently, but it's likely that there are resources like that online from other entities.
Yeah, I'm not aware of one that we've created, but yeah, I'm sure there's some resources online that might cover that kind of stuff. Can look into it, maybe get back to
Yeah,
you
if you want a more detailed answer, you could put your email in the chat. You can make it go just to the presenters if you don't want everyone to see your email, and we can follow up with you. But I think a good way to start would be to just talk with the student about the list of questions that I had earlier about, what are their goals? What kind of things do they think they need help with? What do they want to see for themselves in things like housing, work, training and education, community involvement, and then same questions for the parents to answer for the student, and see if there's agreement on that, or if there needs to be more discussion. Does anyone else have any questions? It could be about transition planning or about the Navajo Civil Rights Act, or IDEA in general.
Okay, and we can stick around for a little longer, but if you guys in attendance don't mind, if you'd like to, I think I don't have this pulled up right here. But if you guys don't mind, if you guys could answer a few questions for us in the chat as well. If you want to let us know if you found this presentation helpful. If it's helped you, please explain. Are there any other topics you'd like us to present on? And then please tell us if you're satisfied with the presentation as well. One of the other questions me and Kayla were discussing too is on the timing of this presentation. We've had presentations both in the afternoon, like after work hours, and then we've also tried to switch it up into this time period too, in the mornings when people might be at work. If there's any preferences that you guys have, please let us know as well, because we want to make sure that our information's getting out to people that will find it helpful, and then making sure we're also getting it to you when folks are available.
I would also encourage everyone to go look at the Law Center website and look at the other recorded presentations on the Self-Advocacy project, because there are more detailed discussions of other parts of the IDEA if you have questions. And you can always reach out to the Law Center if you have questions as well.
Okay. Okay, and then in the chat, I placed my email as well. If anybody wants to reach out and ask questions, I can either help you answer them or connect you with somebody who can. And then as well as our website, and then the list of resources that Kayla was just talking about.
And I just added my email as well.
But okay, we can stay here a few minutes, but again, thank you all for those that attended. We should be having more webinars upcoming that we can keep you updated on our Facebook and our website as well, if you guys want to check that out. And we hope to see you again in the future.
Yeah, thank you so much, everyone who's listening in real time. And if you watch this video later on, have a good day.
I'm gonna stop recording.